Hello, my name is Eric Walker, and today I'm going to be doing a Priceline legal analysis. Priceline is an online travel agency for finding discounted rates for travel-related purchases, such as airline tickets and hotel stays. The company facilitates the provision of travel from its suppliers to its clients. The company facilitates the provision of travel from its suppliers to its clients. It became known for the name your own price system, which travelers would name their price for traveling, whether it's an airline tickets, rental cars, or vacation resorts. Priceline profits from the proceeds are the difference between the price suggested by its customer and the charge by the service provider itself. It claims the price for hotels is 50% off retail, like express deals, instead of showing the geographical location within the parameter. Priceline does an excellent job detailing the user access and the responsibility to utilize their website and service. It recommends that you read the privacy policy, and if you, the user, choose to disagree with the terms and conditions, then you must discontinue use of their site. Having the detailed understanding that the user must discontinue use of the site is a click-wrap agreement, which Priceline is receiving the user's affirmative acceptance electronically. The click-wrap agreement implies that the user is agreeing to the terms and conditions of the company's website and its usage. With the intention to satisfy its customers, Priceline points out how the agreement is governed by the laws of the state of Connecticut. The mandatory arbitration discusses how the claim made by a user can be handled by a small claims court, and under no circumstances may any claim be brought or arbitrated as a class action or proceed on a basis involving the claims brought on a purported representative capacity. An arbitration is a procedure in which a dispute is submitted by a customer or a user of a ISP, Internet Service Provider. The agreement amongst the parties, they opt for a private dispute resolution procedure instead of going to court. The arbitration can only take place if both parties have agreed to it. The procedure for a user of Priceline can send the arbitration by certified mail with a written dispute. In the user notice, they must include the nature of basis of the claim and set forth the specific relief they are after. Between the user and Priceline or a third party being included, if a conclusion cannot be decided upon amongst all parties within a 60-day grace period, then an arbitration can be proceeded. The settlement cannot be disclosed until the arbitrator determines the amount of the third party is entitled. The arbitration must be held at a location determined by AAA pursuant and may mutually be agreed upon. Arbitration clauses do have one important advantage for deep pocket licensors. There are potential means to stop class action litigation. There is no class action under arbitration rules. The furthest the arbitration can be taken through a justice system is to the federal level with the U.S. District Court for Connecticut. The user has the right to dispute any transaction with Priceline, but the process of filing a dispute can lead to the arbitration of Priceline. Since Priceline plays the middle of the travel agency as a product, the companies offer its users range from airline, hotels, to rental cars, cruises, and vacation packages. If you can demonstrate the cost of arbitration will be prohibitive as compared to cost of litigation, Priceline will pay as much of your filing fee in connection with arbitration of the arbitrator deems necessary to prevent the arbitration from being cost prohibitive to the cost of litigation, notwithstanding any other provision or law or any of the rules and procedures established by AAA, which may be the contrary. Priceline would not be entitled to seek reimbursement of its attorney fees for any claim that arbitrator finds to be non-frivolous. Although this is the extent of what can result from filing a dispute, the filing of the arbitration, there are still ways in which a user can sign a false contract with Priceline. Some e-signing or of a contractual agreement can sometimes be non-proven or as authenticity of an electronic signature. The benefit of e-signing process is that the companies like Priceline can provide the opportunity for negotiating and having a near zero transaction cost. By making reservations with a supplier of Priceline, users are accepting and agreeing to the relevant cancellation policy of suppliers as well, which in all cases the cancellation policy of each reservation is made available on Priceline's website. There are some stipulations of credit card chargebacks for the users, as you can see here, such as chargebacks resulting from non-cancelable reservations, chargebacks resulting from charges authorized by family and friends, chargebacks that are arising from the supplier's failure to deliver a product or service, and chargebacks resulting from other circumstances that are beyond their control. The warranty policy is that all content contained within or available through this site are provided to you on an as-is basis. Priceline makes no representation or warranties of any kind, either express or implied, as to the operation of this site, or the information, content, or materials included on the site. Priceline does not warrant or make any representation regarding any kind of suitability, availability of any kind contained within the site, or any purposes including software, products, or services that are related to graphic content. The warranty-related language that we'll use for consumer product click wraps in the U.S. are affected by a federal statute which is known as the Magnuson-Moss Act, which was established in Congress in 1975. This law was passed to help protect consumers from deceptive warranties. The MMA does not require that you provide any warranty with consumer goods while letting you supply your digital goods. Many click wrap EULAs have expressed warranties which generally promise the software will conform to the documentation. Most click wraps have a limited period of warranty, commonly for 60 to 90 days, which gives the vendor the choice of remedies like refunds. Click wrap EULAs generally disclaim implied warranties and consequent damages. However, the Federal MMA Act puts some limitations on this disclaimer for consumer products. To the extent permitted by law, in no event shall Priceline include the receptive officers or any executive leadership involved in creating any kind of promoting or sponsoring of its content to collectively by the covered parties to be liable to any person or entity for any direct or indirect, incidental, or any kind of exemplary, compensatory, or damages of whatsoever. Since the suppliers and the travel services itself, Priceline is considered an independent contractor and not an actual travel agent, which means that the covered parties are responsible for the liabilities of those injuries or any kind of damages and accidents. Nor shall they be any responsibility for the travel service provider's breach of warranty, nor for any other wrongdoing. To the extent not prohibited by law, if notwithstanding the above, a covered party is found liable for any loss or damage relating to the use of the site, users agree the liability of any such shall in no event exceed the total charge to the user assessed by Priceline for making a request. A click wrap usually disclaims an implied warranty, which includes implied warranties of merchantability and fitness for a particular purpose. There is usually a rule that disclaimers of these imply warranties and are ineffective, useless, conspicuous, which is why the disclaimer is in all caps. Normally, it's excluded on consequential damages and to set cumulative cap for the vendor's money damage exposure, which the limit is normally the licensing fee which is paid. The definition of indemnify is compensating someone for loss, or indemnify means to compensate someone for his or her harm or loss. In most contracts, an indemnification clause serves to compensate a party for harm or loss arising in connection with other parties' actions or failure to act. The intent is to shift liability away from one party and on to the indemnifying party. It is also known as a hold harmless clause because one party will hold harmless the other for certain events. The events usually stem from something under control of the indemnifying parties, which again, the party who is doing the compensating of the paying party. In addition to forbidding any of the banned content, terms of use will often include user indemnification provisions. This means the site owner its loss or leads to a lawsuit, the site owner can sue the user and recover all losses, expenses, and fees. Terms and conditions make no mention of the service availability and networking solutions. This disclaimer on the topic of Priceline would recommend adding the section of the clause to the terms and conditions, subjecting it to a rather broad condition that if the company doesn't attempt to always provide service, users should receive additional discounts of 15% of their service fee. An additional recommendation would be stating the use and access to users' personal information. This is a lot of personal data that goes into booking a reservation with Priceline, which would be useful to also have a limit to sharing your personal information with other parties, since it is a middleman in the travel industry. Both will disclose information if it is required by law and in situations involving a threat to someone else's safety. And this concludes my presentation. Thank you.